Hi, everybody. Welcome to Trial Alchemy. And today's guest I'm delighted to have is Walter M. Yoka. He goes by Wally. He's one of the founding partners of Yoka Smith. Now, Wally is nationally recognized as a trial attorney, and he focuses on defending cases such as products liability, commercial disputes, and class actions. Their offices are up in LA. Wally's a fellow of the American College of Trial Lawyers. He's a member of the American Board of Trial Advocates of ABOTA. He served as the president of the LA chapter of ABOTA in 2014, and he currently serves on the executive board and is the immediate past president of what we call CAL-ABOTA, which is an organization of all the ABOTA chapters in California. Wally is also a member of the Product Liability Advisory Council, the International Society of Barristers, and the Association of Southern California Defense Counsel, and he served as the president of ASCDC in the past and also as president of the California Defense Council. He was actually inducted into the ASCDC Hall of Fame in 2008. Wally's received many awards recognizing his victories and his outstanding results. He's been a super lawyer recognized every year since 2004. He's been listed in the best lawyers in America since 2006, and he was named the best lawyers 2018, 2014, and 2012 Lawyer of the Year Product Liability Litigation Defense in the Los Angeles area. So without any further ado, Wally, welcome to Trial Alchemy. Thanks for being a guest today.
Thanks for having me, Monty. It's a pleasure to be here with you.
Well, great. I'm glad you've joined me, and you've got a beautiful day there in LA. So let's start in with this question. Why don't you tell us about one of your most satisfying trial victories? And I know you've had a lot of them over the years, and tell us about one of them.
That's a good question because sometimes, your most successful win kind of can be a loss sometimes if you think about it, right? Because of what you take away from it, how it impacts you in the future. But I guess if I was to think about a win that was impactful for me personally, I would say a number of years ago, I tried a case against a lawyer by the name of Michael Hughes. And Mike Hughes is a very, very good plaintiff's lawyer. I mean, really good. And I had a tough case. It was a cooking oil tanker that got overpressurized in its system, and a large pipe structure broke loose, and it ended up taking out his eye, brain damage. It was a very unpleasant case. And I had an Asian manufacturer of this pipe, and there was a problem with the pipe, something called porosity. And so I knew this was going to be a tough, multiple defendants, multiple themes that the plaintiff was pursuing in the case. And I knew that I had to if I was going to win the case, I was going to have to win it on causation, because I thought for certain that the jury was ultimately going to find that the pipe was defective, but that the incident itself exceeded any specifications that the pipe could have met, meaning it didn't matter how good you made that pipe, right?
Okay. Yeah.
And so the other thing was, in causation, and when you're defending cases, and if you've got a causation argument, it can be complex. And so when you're picking a jury, you have to think about who is going to hear your causation story, who is going to understand that jury instruction, and who could go back in the jury room and explain to everybody what the defense lawyer is saying about causation, right?
Right, because you can't be back there.
I can't be back there, but you got to find somebody that can be in your place.
Right.
So in this particular case, I had the opportunity to keep a lawyer on the panel. Okay. And as it turned out, that lawyer, of course, understood the complexities of causation and ended up carrying my brief, I think, with the jury. So I ended up winning the case on causation 9-3. I lost on liability. I won on causation 9-3. And then the case went really badly against a number of other defendants. And he was a great lawyer and very gracious. But I just remember it taught me a lot about that, because I've had a lot of causation case trials since then. I'll also say, a loss sometimes is an interesting thing, right? Because I always say, if you win a case, sometimes there's not a lot to learn, because whatever you did it okay. But when you lose a case, you got to look into yourself. What did I do wrong? But I tried a case many, many years ago, and it was a high publicity case representing the Hare Krishnas in Orange County on a brainwashing case. A young woman left her home and joined the Krishna faith, ended up coming back home. And it was a really volatile case. And they were, in effect, putting the religion on trial.
Okay. Yeah.
Yeah. And it was an intentional infliction of emotional distress, false imprisonment, even though her actions were voluntary. Long story short. But I was trying it. I was second chairing it with my mentor, a really famous trial lawyer in LA by the name of Marshall Morgan. Morgan Wenzel McNicholas, who was a former CAL-ABOTA trial lawyer of the year. Anyway, so we're picking a jury, and we've got this huge panel, and the press is covering it. This is a funny story. The press is covering it, and we take a break. So we're out in the hallway, and the press is interviewing Marshall. And Marshall had this very deep, resonating voice that was totally distinguishable from anybody else, and he always spoke loud. And he's ripping the plaintiff's case apart in this interview. Okay. And the plaintiff's lawyer is standing there watching it. We go back in. He immediately asks to go into chambers, makes a motion for a mistrial, have to excuse all the jurors. And Marshall says they didn't hear anything to the judge. And I whispered to him, I said, Marshall, they heard everything you said, everything. He said, Walter, don't worry. We're going to be fine on this. And I'll be damned. We brought in each individual jury about what they heard. They all denied hearing anything. And the lesson for me was they wanted to be on this jury, because they knew if they said they heard it, they would be excused. And it was too interesting of a case for them to be excused.
Yeah.
So I thought that was a really interesting trial technique. And he would do that. And sometimes I've suffered for this over the years because I trained under him. And sometimes I think I can get away with what he can get away with. Sometimes you can't. So anyway, sorry. I hope I didn't go too far on that one.
Oh, no, you didn't go too far. Well, let me ask you this, because you started off with an interesting point. In my experience, even though we hate to lose cases, you're going to lose cases if you try them. And I think I've learned a hell of a lot more from a loss or losses than I typically have learned from victories. So can you think of any great lessons you can think of that you learned from something where the case didn't go the way you wanted it to?
Yeah. It's a good question. Let me kind of backdoor the answer to that question a bit. So you're making me think about a case that I had to try twice. Not everybody gets that opportunity. And
I had to do that once. Terrible.
It's a terrible opportunity. I won the first trial. Okay. Tough case. Automotive products case. quadriplegic plaintiff, and it was a tough win. And the judge took it away on a purported juror misconduct issue. I won't relive that. But so I had to retry it. And it was really hard.
Yeah.
Because I exposed myself in the sense of what my themes were, what my theories were,
Right.
how I was going to approach the case. I had an interesting witness issue that was a surprise to my opponent. There were no surprises the second time.
It's all gone second time.
And I worked hard in the run-up to the second trial as to how I was going to do it different. What could I do differently? What kind of surprises could I have? How could I change my thematics in the case? And it was really hard. It just wasn't one of those cases that you could all of a sudden decide it's a different case for you. I lost the second time. So I always say that if you have to retry a case, it's much better to be the loser on the front end, because the loser has something to learn.
Oh, yeah. I think you're absolutely right.
Yeah.
I had that experience once in a bad faith case I was trying as a plaintiff, and the Court of Appeal took it away, got a good verdict, had to try it a second time. Same as you. It's like you got nothing new anymore, and your opponent knows everything you're going to do. I was fortunate to win again, but I didn't get as much in damages, and partially because I think he was forewarned. And so, it's tough. I felt like that's kind of like trying a case two times, like kissing your sister. You really don't love it.
Yeah, yeah, yeah.
Well, you've tried a lot of cases and you've been very successful. So, have you developed any patterns or approaches over the years when you're doing your final prep? I know all good trial lawyers and rebuttal lawyers are thinking about the trial from the beginning, but you got that final prep time. I call it the grind, where you just got to work hours and hours and hours and get everything ready. But what's your approach? How do you get ready in that final stage where you're going, may not know precisely when, but it's coming up fast? What do you do?
Yeah, I guess that's a really good question. One thing that I do is I try to change the environment that I'm in.
Mm.
So I tend not to be at the office. And so, I'm even, pre-COVID, where everybody was at the end and nobody did. I mean, it's so remarkable today. Nobody worked at home.
Right.
Okay. So this is, I'm speaking pre-COVID, because to the younger lawyers, this is going to say, well, everybody works at home. Anyway,
Yeah.
so I would find we had a basement in our old house, and I had an office down there. It's very quiet, and I like going down there. Change of environment kind of gives me a little bit of clarity, gives me a little bit of time away, and be free of emails. Don't be distracted.
Right.
But I find a change of environment is a good thing when you're doing the final prep. I also try to really kind of refocus myself on the beginning of the case, and I know we're going to talk a little bit later about trial themes and what's the most important part of the case and everything.
Right.
But not surprisingly, I try to focus on voir dire, fine tune my opening, make sure that my voir dire is connecting with my opening the way I want it to, fine tuning whatever PowerPoint slides I might want to use on opening, trying to get a sense of who I'm going to see out of the box from the plaintiff side in terms of witnesses, um, and making sure that I have my ducks in order on my cross-exam prep.
Right.
So I think that's kind of where my head would be on that. But I have to tell you, I mean, I don't wait to the last minute in any respect to prep.
Yeah.
So it's a good question you have. It's a really a fine-tuning question because, like everything in life, there's no substitute for preparation. It's just, the way it is.
Well, I'm sure you're preparing for the case from the beginning, and I think good trial lawyers do that. And I think for any case you take, even though most settle, you have to always prepare it for trial and have it organized for trial from the beginning and be thinking about trial from the beginning. That makes it a lot easier when you have to do that final trial prep because you've been getting ready for a while.
Yeah. I mean, I think the mistake most lawyers make, well, I shouldn't say that. The mistake that some lawyers make is on the defense side is they don't think about winning the case from the beginning.
Right.
Right.
I don't think Appellate lawyers do this, but I think I've seen too many lawyers who don't think strategically. It's almost like a cookie cutter process. Well, they know they can do this, they do this. Well, I mean, you got to think strategically. Is this going to help me get a good result for my client? Is this important? And, I think everybody should do that, but not enough people do.
Yeah, that's totally true. Totally
Yeah.
true.
Yeah, well, in terms of let's talk next about trial themes. And you're on the defense side, and you're hearing, the plaintiff's themes over and over. And I'm sure your themes change depending upon the nature of the case. But what would be some examples of some effective trial themes that you've used to defend your clients that you thought were pretty effective?
So when I talk to younger lawyers at our office, this is a subject I talk to them about because people forget that we have to have a story, and you can look at it as a single story with parts to it, right? There's
Yep.
overall thematic to the story, but that story has to be kind of carried out. So your witnesses have to have a story.
Yep.
And that story has to be individual to them. So if you're going to put a corporate witness on the stand, they have to be prepared to tell their personal story, because a jury is never going to understand the witness's believability or credibility without understanding or knowing who this person is. So witnesses, particularly on the corporate side, have to be prepared to be personal, to tell their personal story, right?
Yep.
And then secondly, your company has to have a story,
Right.
and you have to figure out a way to tell that company story, what its history is. And so I'll do things like, if I've got a product case, I want a picture of the manufacturing plant. I want to show the jury what the plant looks like.
Yeah.
I want to make it real to them. This is a real place where real people go to work every day, where they're trying to do the best job they can. So I have to have a company story, a history, for example.
Right.
And then the third thing is what really is the case story, I think. And that case story, look at, Monty, the problem, again, I don't mean to point out anything, but it's look, if as a defense lawyer, if you go into a case that you're just going to defend whatever the plaintiff does, if that's what you're going to do, you're not going to have a lot of success over time, because all you're doing is playing defense. That's all you're doing.
Yep.
And so a defense lawyer has to play offense. And
Absolutely.
and they have to have a theme of the case. And in today's world, in the cases I deal with, the plaintiffs have a safety theme. And you have to have a safety theme to put up against their safety theme.
Right.
And you have to be looking for it throughout the case. You have to be looking for opportunities to tell that story, because you have to give the jury a choice. And so you could have a case where you're representing a product manufacturer that has, quote unquote, bad documents, right?
Right.
Documents that are hard to explain, internal documents that are questioning what's being done and challenging what's being done, and indicating a safety issue, whatever the issue is. Or you could, for example, have a witness that, notwithstanding your good efforts, you just can't get him to be likable or her to be likable. I mean, right? So for example, here's an example. Let's take a tire case. I do a lot of tire litigation. And so let's take a case where I've got, a history of some issues with the tire. I got design changes. I got all sorts of stuff going on. Okay.
Right.
And the theme of the plaintiffs is, well, this tire underwent 3 design changes within 4 years after the tire was made. And my God, had this tire had those changes, we wouldn't be sitting here today. Changes mean it was bad. Okay. All that sort of stuff. Okay. So in those kind of cases, what you got to look for is your own safety thing. So, for example, I've got a 15-year-old tire. I got a 15-year-old tire that was installed 2 days before the accident. Right? It's the wrong size. It's the wrong size tire for the vehicle. The vehicle itself is its suspension system and steering system is old, and we've taken it apart by an expert, and we know that contributed to it. So all of a sudden, I start to develop a safety story, right? So you're buying old used tires. How much do you care about your own personal safety? You're not taking care of your vehicle. So you're not wearing a seat belt.
Yeah.
Okay, whatever it is. So all of a sudden now I have a safety story. And that safety story is going to be told in voir dire.
Yeah.
I'm going to introduce that safety story in voir dire by asking jurors questions that set up what they're about to hear in opening statement. And so, frequently, sometimes maybe I'm going farther than you want me to, but you stop me anyway.
You're doing great. Keep going.
Okay. So, remember, if you've got that kind of story, finding a juror who can tell that story for you without knowing that they're telling the story for you, right?
Yeah.
So I was trying a case, and I think could have been almost a 20-year-old tire. And the plaintiff's counsel identified a juror who routinely bought used tires and got that out of him, and then asked him, and so you like used tires? Oh yeah, I like used tires. Thumbs up. So I went back on him on voir dire, and I started asking him questions, and I started saying, well, let me ask you this, how frequently do you buy used tires? He said, well, I buy them a lot. And I said, so how many vehicles are you buying used tires for? And he said, well, just one vehicle. I said, oh, really? I said, so how many used tires have you bought for this one vehicle, let's say in the last 5 years? I think he said like 10 or 12 tires. And I said, well, that seems like a lot of tires in a short period of time. He says, yeah. And I said, is that because they come apart on you? And he said, yeah, they do. I said, so when you buy a used tire, you know you're getting a tire that's not going to last, right? Oh, I do know that. And you don't know anything about that tire, how it was used. No, I don't know anything about that. So let me just ask you this. When you buy these used tires, you know that might not be that safe. And he goes, yeah, I know that. So why I'm telling this story is that he just gave me a perfect opportunity to introduce my case. So
Yep.
here I have a juror who's telling everybody used tires are unsafe. You ought not to be buying them. I know I'm at risk when I do it. Well, that's my case,
Exactly.
right?
Yeah.
And so, he kicked that juror off, right? He thought he kicked it off,
Right.
but it didn't matter because that theme what was now in front of the jury before I stood up on opening statement.
Yeah. It was introduced.
Yeah.
Well, that's great. I like your point about you have to tell your own safety story. And it makes perfect sense because if you think about just human nature, if somebody is accusing your client of doing something and all you're doing is giving excuses and defenses, people don't like that very much. They're not
They
going to
don't.
respond well,
They
you
don't.
know? But if you have your positive story, and that's what I think, a trial, um, I say a trial is you get to be a movie director and you have to figure out what the important parts of the story are, how you're going to tell the story, and how you're going to persuade with your story. But it's harder than movies because in a movie there's only one director.
Yep.
Whereas in your case with two parties, you got two directors, and they're each trying to bash the other's story. But you have to have a positive story. So I think that's a great point. So let's
Yep.
go to this thing, Wally. You've tried a lot of cases, and this is a question where everybody has some slightly different answers, but there's some that are more popular than others. But in your experience, what do you think is the most important part of a jury trial and why?
Well, I mean, every case is different. Sometimes it'll surprise you when the most important part of the case comes up. Sometimes it's a surprising witness or something you didn't expect, either a plus or negative. And then all of a sudden, the closing argument becomes the most important part.
Yeah, that can happen.
That can happen. But I think in general, it's the beginning of the case. And as I think I commented a moment before, uh, it's voir dire and opening, and I tend not to think of them as being separate. I tend to
Right.
think of them as kind of being together. Um, and so I think that's the most, generally speaking, that's the most important part of a trial. It's where you have an opportunity to establish your personal believability, trustworthiness, your clients. It sets the stage. First impressions are lasting impressions, um, and so that's absolutely key. And as we were commenting before about making sure that your thematics that you're going to talk about in your opening statement are being pushed into the voir dire, so it's a very linear equation. And why opening is really the most important is because, particularly today, it used to be, man, your arms were tied behind your back in opening, but openings today have become much more broader. And there's good and bad to that. Okay.
Right.
And
Right.
there's always a big fight about that, particularly today, because on the plaintiff side, I find that there's just a definite effort to turn the opening into a closing. Okay.
Oh, I think you're right. There's a
Yeah,
lot of that.
a lot of that. So you gotta be careful about that. You maybe can attack some of that, some of your pretrial motion filings and the like. but you've got to be prepared to play that in that world. The mistake that defense lawyers make is not realizing the new world. So you can't act like that you're above that. You're going to have to dig in and do it. But so if I know I've got a case where I have that the key to the case from the plaintiff is their expert, okay?
Right.
Okay, and I got a lot of those kind of cases. And so what I'm going to do in opening is I'm going to just take on that expert right away. I am going to absolutely go after the expert in opening. I'm going to do what might be considered kind of a cross-exam of the expert in opening, because why I'm doing that is I want the jury to get all worked up about this one witness, right? So when he or she shows up, they'll remember that's the guy Yoka talked about.
Yeah.
Now we're ready to hear, and oftentimes, plaintiffs will strategically. I've had it happen many times. I've had it happen a couple of times where the first witness, and I knew it was the first witness out of their buck, was going to be their expert.
Their expert, yeah.
So I have this unfettered, unrebutted opportunity in my opening statement to basically preview a cross-examination of their expert. And they put the expert first on the stand because they think that getting that liability issue in front of them right away is a good thing. And it could be. I'm not saying it's not. But if I know that, I'm going to definitely do that because I get that first bite at that. Before he even puts the expert on the stand, he now has to be defensive of the expert.
Yeah, that's a great strategy.
Because he knows the jury just heard all this.
Yeah.
So now he's got to try to figure out a way to kind of rebut it. So
you're telling your story first regarding the expert, and the plaintiff probably hasn't talked about him that much.
The thing that with openings people forget about is it's kind of the defense closing statement because you get to go last.
Yep.
And
it really is your closing statement you get in the case where you get the last word in that section.
Before they hear any evidence. So that's the last thing they hear. So you've got to figure out in that opening your winning strategy. That it's not enough to get up and do this typical standard stuff. You got to do all that, but you've got to have that winning opening strategy from the beginning.
Have you ever worried when you're going after their expert in your opening statement and really doing a cross on them that they're going to be able to use that information to try to make them look better on the stand or her look better on the stand when they come up for their real testimony?
Yeah. I mean, look that's a good point. Not every case is the same. Not every approach is the same. Sometimes you may want to hold back a little bit. If you feel like that this witness could be potentially likable, but what they say is total nonsense.
Yeah.
Then you're going to want to kind of figure because you don't want the jury to feel sorry for the witness.
Right.
I always say, if I end a case and if I'm talking to the jurors afterwards, okay?
Yep.
And if a juror says to me, I would have been much tougher on that guy. I would have really gone after that guy. I would have been much tougher. I love it because I think I've done my job because
you have.
Right. Because that juror has stepped in my shoes.
Yeah.
That juror now wants to do my work. And because you always have to watch this, how crossing the line. How far do you get to the line where you get too aggressive with a witness and then the jurors feel sorry for the witness? You You want to stay behind the feel sorry line.
Exactly.
So if a juror comes back and says, I would have been much harder, I would have gone after them, I say, I must have done well in that case. If a juror is going to come back and say that.
Absolutely, you did well. Well, and now in dealing with your voir dire and your opening statement, let me ask you about this. What do you think, or how have you felt about the development of many openings that have developed in recent years? And what do you think about it now? Maybe you didn't like it at the beginning. Some defense lawyers didn't, but what are your thoughts about it now? How do you use it?
Yeah. Listen, I think you summed it up. I think that when this came about, it felt very threatening to defense lawyers.
Yeah.
It kind of felt like that the plaintiff's lawyers were being given an extra opportunity to spoil the jury. And so defense lawyers fought it. I think I fought it early. And like so many things in life, what appears to be first a negative, you have to turn into a positive. So I call it, in my world, I call it embrace the negative. And I think defense lawyers have to embrace the negative, because if you don't embrace the negative, you're going to lose.
Yep.
Okay? Because you're going to have a negative. I got a little off the subject, but remind me to come back to that one point. But in any event, so yeah, so no problem. You want to do a mini opening? Let's do a mini opening. I just want some parameters set. I want to make sure that we have a limit. We know what our time limitation is, and that the judge is going to abide by it.
Right.
Okay? I want to make sure that the mini opening is not the equivalent of an opening statement. That is to say, it's informative, it's non-argumentative. So I want to kind of, so if I'm going to have some pretrial discussions with the judge, I'm going to lay out that kind of thing and get the feedback from the judge, so I can get a commitment from the judge if the plaintiff's lawyer kind of exceeds those bounds. And then the judge will be sensitive to it.
Right.
But that's kind of how I feel about it.
Okay. So now going back to the voir dire and opening statement time period, they're all connected. You're trying to sometimes talk about your theme, like you gave with that example of that one juror, but I'm sure you're also trying to, as much as you can, see if you can develop uh, excusing people for cause and saving some of your peremptories. Are there things you've done over the years that you found helpful in that and trying to get people out for cause and giving you some more peremptories left over in your quiver?
Yeah, I think every trial lawyer does it. Um, um, have to be careful on your for cause challenges,
Yep.
Particularly if the examination of the juror in front of everybody is becoming a little difficult, uncomfortable, So you know, but yeah, I mean, look, you need to find a way to unearth that anti-corporate feeling. And if you can find a juror who's going to confess it, that's not a bad thing.
Right.
I mean, that's just not a bad thing for me. So I don't mind getting a juror to admit that they just cannot be fair. And that they have an anti-corporate attitude and mentality, and they can't put it aside. I mean, I'll do that. No problem, because then I'll loop it, right? So once I get a juror that says that to me, then I'll say, okay, you heard what, Mrs. So-and-so had to say here. How do you feel about that? Do you agree with her? Who amongst you agrees with her? So let's get it out.
Right.
Let's not. So, I think judges, my feeling is lately is I think judges are not as willing to remove jurors for causes they once were. I just, I think they have, more of a sense of trying to keep, everybody's got opinions. You can hold your opinions on one side, that whole thing that judges so often do to you, to rehab a juror, right?
They do that all the time.
They do that all the time. And, and I don't like it. I fight it. I'll argue with them. I'll say, when did you become the trial lawyer?
Well, if you got the witness jurors say they can't be fair and they think that they're not going to be the right kind of a juror, the classic line is, well, will you listen to my instructions? Can you be fair and impartial? But that really doesn't solve the problem. But a lot of judges go, no, I'm going to keep this person on.
Yeah. Yeah.
Yeah.
Totally right. Totally right. So yeah, I mean, it's just a chess match on that, as you know, and as all trial lawyers know, is managing your preemptory challenges with and try to reserve them. So yeah, and also in my world, every jurisdiction's different, and in terms of the process, procedure, jurors you're going to get. And so it's always a different environment, and I do so many cases outside of California that it's always, it's so funny how some themes work in some places and they don't work in others. There's a ton of themes, for example, down in Phoenix that work for defendants that don't work up here.
Yep.
You
have regional differences.
Totally regional differences.
Yep.
Totally. So knowing what plays and doesn't play, is obviously key. So hopefully I answered that for you.
Yeah, you did. Have you found in your jury trials, in the last 5 years or so, that you're probably starting to see some more of the younger generations, like millennials and Gen Zs? Are you noticing, do people in those age groups have any different characteristics that you've observed, or are they similar to other generations?
Well, as there's so much talk about this subject and seminars on it, and people write about it. I mean, look, I don't know that I have the magic on this, Do I think that this Gen Z issue and the post-COVID environment, do I think that's been a positive thing for defendants? I don't,
Right.
Is there an anti-corporate environment? There obviously is. Has it been any in our recent past history, has it been any worse than it is today? Probably not. Have corporations ever been loved? No. As I always do in voir dire, I always say, I represent ABC Corporation. And this lawyer over here, he represents this wife who lost her husband. He's got an actual person to represent in this case, and I got a corporation. And this judge here, sitting here, is going to tell you one of these days in the case that my client as a corporation should be viewed by you just like a person in the eyes of the law. My company's no different than Mary Smith. That's what the judge is going to tell you. And this is what I always say. But nobody believes that. I mean, nobody believes that. I mean, ABC Corporation is not the same, right? So that's the law. You need to abide by it. But in reality, that's not really how people think, and it's not how you think. So let's start there. So what I try to do is I just try to acknowledge that,
Right.
I think that, look, The anti-corporate environment is obviously fueled by uh, by by a daily dose of corporate greed stories, of CEO salaries. It just goes on and on.
Yeah.
So when you're representing a corporation, if they're going to give an award, they think that they're giving away money that the corporation is lavishing on whoever. Okay. And that's a problem for defendants. I find that it's not that cases can't be won for defendants. Cases can be won for defendants. There's no doubt. But if you lose, you stand a good chance of losing for a lot more money than the past.
Yeah.
And so that's the real issue. I think also that one of the things that I think gets mileage against defendants is if you have the feeling sometimes that jurors are going to hold your corporate client to a higher standard of care or conduct than maybe the law actually requires.
Mm-hmm.
And that's an issue that you've got to, be actively involved in and deal with. So let's say you have a case where you've got some companies, hypothetical.
Right.
The plaintiff's case is an attack on what this particular company witness did and how negligent that witness was and how poor the training was. And then in discovery, it comes out that the training that the company does is 5 months worth of training. Turns out that this guy skipped out on half of it or a quarter of it, a third of it, whatever, so that he wasn't trained pursuant to the company's own training system, and the company's own training system exceeds what is the standard of care. It goes way beyond what a typical business would do under those circumstances. So now all of a sudden you've got a case where the plaintiff is using your training methods against you, using your higher standard of care against you, and then using this employee's failure to complete a testing program that exceeded. That is a problem kind of a case. And so you got to identify it. But it does feed in to this discussion we're having on this kind of anti-corporate environment, because jurors will look to hold a corporation to a higher standard.
What kinds of things do you try to do to deal with those tendencies?
Yeah. So it's a good question. And I think, first of all, recognizing that's what's going to happen. You got to recognize the problem. And two, I think that you have to embrace it. You can't run from it.
Yeah.
So my hypothetical. So what you would do, I think, is to say, well, of course we have a higher standard. That's because we care so much. And yes, it puts an extra burden on our company. We have to do more, but that's who we are. We want to make sure it's safe. So in other words,
that's your safety story.
That's right, because we care that much. Now, for example, if you have a bad document that they want to run with, I always say, don't you run from your own company's document.
Right.
So they want to put it up on the screen. They sit down. I put the same document back up. Let's talk about the document again. I want to walk you through this again. The idea being is that at some point in time, the jurors become comfortable with it. once they become comfortable with it, then they want to see what else you have.
Yeah.
Okay.
That makes good sense.
And you know, and there is this issue that people kind of don't realize sometimes. I won't identify the case or the lawyer on this particular one, but I thought it was very effective. The client, the plaintiff, was a very, very sympathetic quadriplegic, and a bunch of plaintiff did not show up in the trial, but people were telling the story of this plaintiff. And when the plaintiff finally showed up for the single day, I could just tell the jury was just anticipating, you know?
Yeah.
And it became a very emotional thing. And I thought, wow, that was very effective.
Yeah, that was effective on the plaintiff's part. If that plaintiff was sitting there the whole trial, would not have had that effect.
Because it's called comfort, right?
Yep.
Because then you become comfortable with it. You see it every day. Oh, okay.
Yeah.
That's my point here is that if you have something bad, you have to find a way to get a level of comfort with it. How do
Yeah.
you embrace it? Don't run from it. Because if you do, the juries will know that you're doing that. Then once they know you're afraid of it, then you're done.
Well, the other thing is, if you're running from something, you're probably going to lose credibility in the eyes of the jury. And if you, as the lawyer, lose credibility or your client loses credibility, your witnesses, that's really terrible for your side of the case.
No doubt. No doubt.
Yeah. You got to be willing to talk about it and all that.
Yep.
Well, now we've picked a jury. You've given an opening statement. We've talked a little bit about all those things. Now, one of the things that happens during the trial, and you alluded to this earlier, is, and this can be very significant and can be a very important part of the trial, is cross-examination can be very important in a trial. And I think it can win or lose cases depending upon how critical witnesses do, whether it's really well or really bad. So, what's your approach to cross in doing what you have to do and cross-examining the witnesses of the other side?
Yeah. Yeah, that's of course just wow. That's what it's all about. So let me just kind of throw out a few ideas here. I first of all, I think it. I don't think one cross-examination fits all. If you have a really, really good expert
I agree with you.
on the other side,
Yep.
you have to be surgical. You have to get that witness on and off the stand, and you need to make some key points, get some concessions that you think and know that you can get. Don't overreach.
Yep.
Get them off the stand.
Right.
Now, the alternative is you've got a expert who you think you can dismantle. And so that's a whole different approach.
Yep.
Um, and but you also have to be somewhat surgical because you don't want them on the stand for 2 days. So you have to have a very tight outline, and the other thing that I tend to recommend to people is if you've got an expert whose qualifications are iffy, right? Who's kind of marginal. And you can do more of this in federal court, I think, than state court. But I like to take the expert witness on voir dire during direct examination.
Or their qualifications.
Right. So I want to interrupt the direct examination. And I also want to begin to give the jury a taste of my cross before I start. And every so once in a while, you might get it, you might get the objections sustained to some degree.
Yeah.
You do your voir dire, and that is a not so good thing for the plaintiff.
That's a monumental problem for the plaintiff.
Even if you only get part of it,
Yeah. Right.
Yeah. So, so, um, that's there's some of my comments on experts. On plaintiffs, of course, there's no winning the case by examining the plaintiff, with some exceptions. Depends on the case. Sometimes you can, because the plaintiff is such a bad witness, not telling the truth. You've got him, whatever it is. So the examination of the plaintiff can be very important depending upon the case, because if you can convince if a jury, as a result of your examination, loses their sympathy for the plaintiff, then the plaintiff's done.
Right.
Then the plaintiff is
well, if they lose their sympathy, or if they don't like him or her, they're done.
They're done.
Yeah.
So you don't want to screw up a good thing by making them likable. Okay. So right. So damage witnesses, particularly damage experts, you have to be very surgical with. You don't want them on the stand too long.
Right.
Make points, get out. You have to be careful how much damage witness testimony on your own you put on. You don't want to talk about damages. So, you have to be careful about that sort of thing.
Right.
But I think cross-examination is not only the key, but it's the most fun.
Definitely the most fun.
And I've got a son-in-law that's a plaintiff's lawyer. I've got a son that's a plaintiff's lawyer. And I always tell them, when they're kind of getting ready, I always say, remember, have fun. Have fun. Because, and I don't mean that in a sense of not recognizing the seriousness or importance of what you're doing, but fundamentally, if you've got that in your head, that I'm enjoying this, I'm having fun doing this, then you're going to have a lot more success, because it creates it kind of creates a comfort level for you.
Yeah. Well, speaking about fun, I wonder if your experience is similar. My experience in trying different cases over the years is the prep time and the work time, that's just kind of a grind. But once the bell rings and you're in the arena, it's fun.
Totally right.
You're just going and you're reacting. But if you've prepared well, you got everything ready. Stuff's going to happen, and you can't anticipate everything, and you got to deal with stuff, but that's part of the fun.
It's funny. We're talking and you're making me think of stuff. So you'll get a kick out of this story. So I had this case a long time ago, and I always felt that the plaintiff was not being candid about the extent of her injury, blah, 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 blah.
Okay.
So I got her on sub rosa. Okay.
Yeah.
And it was great. Okay. It was in Hollywood, and there was this gym, and on the second floor of the gym was a kickboxing thing. So this investigator was a really smart dude. He got on the parking lot across the street, okay, on the top part, and he could see right through there.
He could have a great view, huh?
Okay, so we had film on it, So I think I'm setting this up, and an opening and everything, blah, 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 blah. and it's kind of killer. Okay. And so she goes on direct examination. She tells this awful story. So I'm cross-examining. And so I think I'm doing pretty good, kind of setting it up, getting her to give me some admissions about, oh, so you can't move this way, you can't do this. So I'm setting the whole film up, okay? All of a sudden, she looks at me. I mean, she looks right at me, okay? And I think, uh-oh, she's figured out I got something.
Oh.
Okay. And I thought, oh, I went too far. I went too far in the setup. I kind of, I unveiled what I got. And so then what happens is I start asking her questions and she starts backing off of her injury. She starts kind of saying, well, no, I actually, I can actually do that. No, I can actually do that. No, I can. So she started all of a sudden kind of changing it.
Wow.
And diminishing her injury, And so I couldn't use it because I was then afraid that if I used it, they'd be sympathetic to her.
Yeah.
Okay. And I guess the plus of it was I had something to talk about in a closing statement. That it was a liability case and they just didn't give her that much money because she kind of backed off.
She backed off. Yeah.
So I guess it was effective, but it was so funny. She just looked right at me. She looked right at me, and I said, "Oh, she knows that I got something." So anyway.
Well, you may not have gone too far. She may just have been clever enough to realize, uh-oh, he's got something.
Yeah, yeah.
I had a case where somebody was claiming they had TMJ a number of years ago, and we had been looking around. I was defending the case, and we found a declaration for a restraining order saying it turned out about a week before this car accident, her boyfriend had beat her and hit her around the head and the neck and all this stuff. And of course, that can cause TMJ.
Yeah.
So she gets on the stand and, she tells her story, and I get her to confirm and cross that, oh, no, she's never had any, damage to the head or any accidents or anything like that. And I was able to bring out her own report and just totally killed the case. So
Yeah.
that was pretty fun.
Yeah, totally. Yep.
On that one. Well, let's finish up with a couple of things here. Now, when you've put on your case, you've done your direct and cross and all that, now you're going to make the closing argument. What's your strategy and approach there in trying to close it out and get that verdict that you want for your client?
Yeah. I try not to overdo a closing argument. I try not to go into it thinking I'm going to win the case on the closing argument. I try not to feel that it's a win or lose proposition, if you will, on closing argument. If I did a good job on the case,
Yeah.
I'm going to want to, thematically tie it into my opening. I'm going to want to go back and revisit my opening with the jury. I'm going to say to them, remember, I told you this, I promised this. Did I deliver? Here's the evidence. I said this was going to be the evidence. Did this turn out to be the evidence? And I told you that if I did these things, I was going to be entitled to a verdict from you. And I think I did these things. So I try to take the opening, my promises to them in the opening, and my delivery on those promises. So it's part of, establishing my credibility with them. So that's one thing that I definitely do.
That's important.
Yeah. I
Do you ever show that the plaintiff didn't do what they said they were going to do in opening statement?
Totally. And sometimes, you'll get portions of transcripts from the trial or the opening.
Yeah.
I'll use that. I'll use that particularly if it was a particularly important question and answer that came out. I'll show the jury that. So I think that's just kind of in a real quick summary. I think what I try to do, but I do think it's important to remind the jury that I delivered on what I promised.
Right. Now, let me ask you this. I mean, you're dealing with a lot of cases when you're dealing with product liability and other kinds of serious injuries where there could be a lot of damages if the plaintiff prevails. And I know you're trying to win on liability or causation, but I also suspect you're going to talk about damages. And if you do talk about damages, what information are you trying to give the jury to help them figure out, if they get to that issue, a reasonable way to put dollars on injuries?
Yeah. Well, that's always the big deal, right? Do you give them a number or not? And that whole thing has been debated forever and will always be debated. And there are some people who feel very strongly that you don't ever give them a number. There's people that feel strongly the other way. I tend to feel I tend to feel like it depends on the case.
Okay.
I try to be nimble in that regard. I try not to be so set. I'm going to make a judgment here. If I really feel like the case went in really good and I'm very good on it, I will talk very generally about the damage issues and if it's an overreach or whatever, but I won't give them a number. If I want to kind of alter that, I might focus on how they overreached, how their expert was shown to have done this wrongly or improperly or this damage claim, to try to establish a credibility issue with their damages.
Okay.
And maybe not give a number. Maybe it's a case that I'm a little uncomfortable with in terms of how it went in, and I don't want to get hammered. So, I might give a number, or I might really talk about their number, their overreach of the number, and their overreach of the number is consistent with their overreach of the case. Why would you be surprised that they asked for $40 million on this case when they said this to you? So, they're not delivering their promises here, and it shouldn't surprise. So, and I tend to want to make the plaintiff's lawyer defensive a bit, because I want the plaintiff's lawyer to talk about me in the rebuttal. I don't want to talk. I want Mr. Yoka said, that's okay. You can talk about me all you want, because you're not talking about your case.
Well, if you get them talking about what you said, you've won that round.
That's right. That's
definitely.
Right. Yeah.
Okay, well, that's good. So you don't do it just one size fits all and you modify it. Well, Wally, this has been a great conversation, and let's close it out with this question that I like to end with, and that is, you've tried a lot of cases. You and I have been doing this a lot of years, and so you may have gotten some advice when you were young and learning how to do this, or you may have learned some things over the years where you would say, here's the advice I would give. What advice would you give to a younger lawyer who has maybe tried no cases or maybe only one or two, about what can they do to try to become a competent, capable trial lawyer?
Yeah. It's a really good question. I guess the first thing I would say is there's just no substitute for hard work. There's no shortcuts. The harder you work at the beginning of your career, the better you're going to be, because you're laying the foundation. So there's just aren't any shortcuts to this.
Yep.
And I think the thing that maybe people really don't realize, the mystique, the glamour, the funness of being a trial lawyer, all that kind of stuff. It's fundamentally a really hard job. And it takes a lot out of you.
Yep.
I think that I would first say, if you're not prepared to work hard now, you're never going to be prepared to work hard. So that means, working on the weekends. That means working late hours. That means putting the extra time in. Because that's the foundation you're laying for. So there's no shortcut. So I think that's the first thing I would say. I think the second thing I would say is be open-minded, be prepared to learn. And I know that seems obvious in most people, but sometimes, particularly in today's world, and everybody thinks they know. There's just like, knowledge is easier to come by, whether it's good knowledge, whether it's truthful knowledge, I can't say, but it's easier to come by.
Yeah.
Okay. And so people have a tendency to think they know without having had the experience of doing.
Right.
So don't be arrogant about what you think you know. Be open-minded. Be a good receptor of information. The third thing I would say is be yourself. Don't try to be anybody else. You may get mentored by somebody.
Yeah.
You may see something you like, but be yourself. Be comfortable as who you are. I like to tell young lawyers, the moment that you feel as comfortable in front of a jury as you feel comfortable in your living room, having a drink with your friends and family, the moment that those two things are equal is the moment you've become a trial lawyer.
Yeah. And you got to be yourself. And you can learn from great trial lawyers all kinds of great techniques, but it doesn't mean you can do them, because there are plenty of times you can't do what they do.
That's right.
But they can't do what you do.
That's right.
Yeah. Well, those are great tips. Thanks so much, Wally. Thanks so much for taking time today and sharing your knowledge and your expertise, and really appreciate it. So thanks for being a guest today on Trial Alchemy.
Thanks for having me.